National Law School, and I specialize in criminal law. I've got with me Professor Stanley Yeo, who's also a professor of criminal law and based at the National University of Singapore, and Professor Wing-Cheong, who's again a specialist in criminal law, based at the Singapore Management University. So Stanley and Wing-Cheong are here at the National Law School for a teaching workshop on criminal law that we're organizing here. And so we thought we'll have a conversation about various issues on comparative criminal law and criminal law teaching. So let me begin. So let's talk about scholarship in criminal law, specifically focusing on the Asian region. So here in India, as you know, most of the criminal law scholarship has tended to be looking at maybe UK or the US jurisprudence, and we haven't yet built a culture of Asian jurisprudence on criminal law. So maybe we can begin by talking about that Asian jurisprudence of criminal law and how to sort of integrate it into India as well. So Stanley.
Okay, yeah. Thanks, Mrinal. On behalf of Wing-Cheong and myself, it's a great opportunity to be participating in the forthcoming workshop this weekend, where as criminal law teachers with many years experience, we will be sharing and also learning from other criminal law lecturers in India about how they teach criminal law, rightly or wrongly. But in relation to the scholarship of it, yeah, so I think first and foremost for listeners who are not familiar with this, in Singapore, where both of us have taught and still teach, the Singapore criminal law is actually effectively Indian criminal law, because we inherited what used to be called the Indian Penal Code and now the NLS, right? So I think talking about legal scholarship, both of us have been had a great opportunity and privilege to actually write a textbook on a critical commentary on the Singapore Penal Code, where we have managed to actually draw on Indian developments, your Supreme Court decisions, legislation, and so forth over the years. But in addition, because there has been a robust, especially judicial culture in Singapore, of actually citing legal scholarship, including our textbook, we have been encouraged to actually also explore further afield beyond Singapore and India to the British common law, but also other jurisdictions in the region as well, and integrate that into our legal scholarship.
Yeah. So maybe picking up on what you were saying about comparative criminal law scholarship, why studying Asia may be more relevant than some countries like in England or Australia. I think for our countries, we share a lot of things in common because of the colonial heritage and also the makeup of the population being multi-religious, of different ethnicities. So I think our circumstances are quite different from maybe England or Australia or Canada. So to compare our laws may be more instructive, more useful, shared history of colonialism. So I think we may have some laws that we can learn from each other. And so I think that's the benefit of our comparative kind of criminal law project.
Also, I think that Stanley was saying that many jurisdictions, Asian jurisdictions and African jurisdictions, all derived from the original Indian Penal Code, and they used that as their base. Sometimes I think exactly the same thing, and some others added or deleted from the original Indian Penal Code. So then it's a natural fit for us to compare or learn from each other's jurisdictions, from case law that's happening across these jurisdictions. So how is homicide law being looked at in one jurisdiction or other? So you have done work on homicide law, you try to compare Australia and UK, US and India, and then you conclude in your work that the original Indian Penal Code was a better model, right? So can you tell us a bit about that?
Yeah, so the provisions in the Indian Penal Code on homicide is what I regard as the schematic approach. Is the analogy of a ladder. So the highest rung in terms of culpability in the Indian Penal Code would be murder, right? And murder is definitely defined in a particular way, and the commensurate punishment would be the highest form. And then further down, the culpable homicide not amounting to murder, lesser punishment but still severe. And then further down the ladder would be rash act causing death, and then right at the bottom would be negligent act causing death. So there's this hierarchy or scheme in terms of graded fault, the level liability of culpability and commensurate punishment. So by contrast, in my study of the English or the Australian common law on homicide, to this day, they are fragmented. There is no flow, general flow. So, for example, in England until this day, if you commit homicide negligently, you could still be convicted and theoretically punished for manslaughter, which attracts life imprisonment. So there's just a disjunct there. So actually, even though the IPC provisions on the homicide are 19th century instrument, there was a lot of serious thinking by the drafters, right, to actually come up with this kind of principled formulations or schemes to determine culpability. So there's a lot that actually other legal systems, like including England and so forth, that actually are learning about and rethinking about their laws, like such as homicide, by looking at the IPC, rather than, I think there's a tendency by some, especially lawmakers and judges in India and elsewhere, to actually refer to England as if they are the repository or of the best knowledge. But actually, in my over years of researching on many aspects of the Indian Penal Code, is actually I found them to actually be superior in terms of the reflection and the thinking of on criminal law matters.
So that's on the conceptual level, which will say that if you look at the laws themselves, Indian Penal Code was more superior.
Yeah.
But in the interpretation of those laws by courts, do you see an understanding of the concepts coming through? Like you said, if you look at something like reckless homicide and negligent homicide versus other forms, intentional homicide, do you see that coming through in interpretation of courts?
By the courts.
Yeah.
Interpretation of the
So Stanley's point, of course, is that conceptually this is good. But as you've written books on various IPC jurisdictions, do you see that conceptual clarity in the code translating in court judgments? Or is there confusion? Are courts getting confused?
I think generally courts can see the structure, the gradation that you talked about. But I can give an example where there's borrowing of laws which do not belong in this structure, and that's caused a problem. And that's in the case of road traffic, right? So our countries, we have this nice gradation of the seriousness of that crime. But I think both our countries have introduced road traffic legislation for death caused by motor vehicles, with a different kind of mental element that's required, whether it's reckless driving or dangerous driving. So they've introduced new terms, and I'm not quite sure how it fits within this nicely laid out model in the Indian Penal Code. And it goes back to what you said earlier about looking at sources from England, right, and transplanting it into our countries where it doesn't really fit, where there is a codified structure which has been well thought out, and we should be more faithful, I think, to that structure.
Yeah.
And I think just to add to what you're saying, if in England we had this entire subjective versus objective sphere debate, especially in the context of recklessness, where the case law went back and forth from subjective to objective, back to subjective. And if you borrow that without understanding the structure of the homicide laws, as Stanley is saying, you're going to land yourself in conceptual confusion, because that's in a different context. So I think that's the importance of comparative law, that you don't compare apples with oranges, that you follow methods of comparative law. So keeping that in mind, as you wrote these books on various jurisdictions of the IPC, what was your experience? Maybe pose that to you, Wing-Cheong. In looking at these various systems and bringing all of them together in a cohesive way in a textbook. So you've done Sri Lanka, you've done Laos, you've done Myanmar, you've done Bhutan, and we're doing India, right? So as we look at all of these together, what's that experience been in looking at various comparative features of a set of offences? And
It's been fun, but it's also a learning experience, right? You think you know what is the law, you've been teaching it and researching it for such a long time, but when you try to dig around and learn from other jurisdictions, we find that there's actually a lot more that you don't know. And that supplements, right, your own research and your own interpretation of some of these issues as well. And to find out maybe some places they have amended their laws to deal with certain problems that we are facing, right, in our own jurisdiction, and look at those solutions. So it's a great learning experience to come out of our small shell, I think.
Yes, I think it's reminded of an analogy of, I like to eat fish, right? I'm going to Kerala, I will see great seafood and so forth, right? Looking forward to that trip very soon after the workshop. But, I fish for my fish in my local pond, right? Now, I get good fish, right? But if I was prepared to actually go further and fish in the river, better still go and fish in the ocean, right? I'm going to get different varieties of fish. So it's the same thing with comparativism. As a legal scholar in the realm of criminal law, right, I can be confined to India or Singapore and talk about it and think about it. But if I'm actually open-minded actually as a comparativist, I say, okay, like Wing-Cheong says, similar problem, homicide has happened on the road or in the house, domestic violence and all that. These are social problems that cut across borders, right? So what is Singapore doing? What's Australia doing? What's England doing? What is Sudan doing in relation to these kinds of areas? So I'm in the same way as being prepared to actually fish and find solutions, possible solutions in other countries that share the same social problems. And that's basically what I think legal scholarship that has got a comparative flavor about it seeks to achieve, right? And it's very exciting work.
And as we're doing the India book, I think as I'm writing parts of it and doing this comparative work, you say, this concept is so clearly explained in the Sri Lankan case and some other concept in a Singaporean case, and it's so useful to get that, say, into Indian jurisprudence. But if we're insular and we're looking only at the pond, you're missing all the great things that are in the ocean. So I think since we're doing a workshop on criminal law teaching over this weekend, what is your sense on pedagogy of criminal law, especially maybe the lack of scholarly materials in the Asian region, which we spoke about earlier? So any thoughts that you have on criminal law pedagogy?
I think we all have our own pedagogy, what we think works after some years of experience, right? So I think at this workshop, we're going to share what are the different ways. Some places, as you said, may not have enough teaching materials. And how do we cope with that? In some places, maybe you have limited time or too many students. What's the technique? So I think we're going to share all that. But I think ultimately we have to adapt and pick up the ideas that we think will work for our own situation. So I think this workshop will be a great kind of sharing of ideas.
And Stanley, yesterday when you were talking to colleagues and students here at NLS, you were giving advice. You had a slide of 5 or 6 things that you as a young academic or even an older academic or a law student should do. Maybe share that to a wider audience. What would your advice be if you are getting into any sort of legal academia, not necessarily only criminal law, but what should you keep your eyes open for?
Well, as far as emerging as we always got to start from the beginning as a legal academic. So you start raw as you go. You start lacking in confidence. And one of the main things that I learned from my own experience was we need to open the door, seize the day as it were, when opportunity arises. Now that involves a lot of courage. That involves exposing myself to being vulnerable, especially as a legal scholar, when I propound some kind of view, an opinion about how the law ought to be, or what I think is effective in the law, right? And invariably, because of the nature of law, there will be differences of opinion. And then when, as a young scholar, I submit my piece with trepidation to some scholarly journal, and I get hit, right, by very scathing reviews. How do I take this or not take this, right? And actually, my advice from personal experience, I've been affected in the past. Oh, you want to write this anymore because it's so painful, right? But you pick up the pieces and you go again, right? And after a while, with time, as with most things in life, right, through patience, through experience, through being thick-skinned, however you call it, you just carry on, and there will come a time when there will be barriers that actually don't seem to be barriers any longer, right? And then you just move on all along. So I think that's one of my first things to encourage young scholars and so forth, is that you open the doors, you try, you take courage, you take strength, you be prepared, you be open to criticism, you know your strengths and you know your weaknesses, and you find companionship, right? Try to find a mentor, right? Someone who actually can guide you, or try to find a buddy, a contemporary, someone who's got things to co-work. So Wing-Cheong and I, over the years, I'm older than him, right? But we worked together collaboratively for 18 years, right? And we work well, right? So I think these kinds of having a mentor or a companion, a team member in the journey as a legal scholar has a lot of benefits, because you actually have some kind of support, right, with the ups and downs in one's legal career.
Right, and again, one thing that we were discussing just earlier with the talk that you gave was about teaching. Why should you get into a teaching profession? What you get out of that, and you were talking about how you hope that the law reform that happens to your students, etc. Right. So, any thoughts on that?
Yeah.
Yes.
Well, just to say that, being a teacher has been a great privilege, right? So I was stumbled into because I wasn't made up. I knew I wasn't made up to be a legal practitioner, so I just kind of moved in that direction. But very, very fortunate. A teacher, I mean, from the Sanskrit, it's a Sanskrit word of guru. So it's a kind of a privilege to actually be a teacher, and you've got these brightest minds of the country you live in. They come and all very eager to learn, right? So what a privilege to actually present one's thinking to help formulate their minds to become legally trained, and then over the next few generations become the future legal minds of the country, right? So we were talking about the role of legal scholarship. That might not happen immediately to influence our current judges or legislators to change the law that they have proposed or ought to be changed, right? But I think there is this other longer-term dimension of being a teacher, being taken seriously the way we teach criminal law or what other forms of law, and how we seek to mold the future leaders of our country who will take up legal positions, either on the courts or as legislators.
I'll just add to that, Wing-Cheong Chan, can take both questions. So as teachers, like Stanley is saying, you would hope you teach the laws or to discuss various issues with your students and hope that you also and they make a difference going forward. But why should you write them? Right? Because both of you have written extensively on issues of criminal law. What is the utility, or what's the motivation behind writing? Can't you just teach and keep it?
I mean, there's one practical answer, which is like it's part of the expectations, right?
So leaving that aside.
Leaving that aside is, I guess, standing by your thoughts. You want to share your thoughts, and hopefully in the future, someone somewhere will pick it up right? Because usually an article is going to discuss the present state of the law, and it suggests how it can be better, right? So, as I think Stanley has said, the reward may not be immediate, but hopefully sometime in the future, someone will pick up. It could be a former student who remembers that lesson, has read that article, who will pick it up later when he's a lawyer, judge, or legislator. And that's a kind of an affirmation that actually someone has seen the value. Yeah,
That's right.
hopefully not too long, not too far in the future.
Yeah, but I like to also introduce, maybe it is a Buddhistic, there's a counterpoint to it, right? So we are serious about our work, we put our energy and our thinking in how the law and all that, but at the end of the day, we also have to learn to let go, right? And I remember a senior professor when I was a young academic, and he had this very long way of making a very simple point. What he did was he took me over to the library, to the bottom, right, at the basement where the books that were no longer in use were laying down there in the stack room. And he pulled out this book, was by Pillman, written in the 1920s. And he said, do you know this book? It's criminal law book. He said this was the top criminal law textbook happened in the United States. Do you know this guy? I said, I never heard of him before. So Stanley, relax. 50 years, 20 years maybe from now, nobody will know you, right? So enjoy life, you can work very hard, but don't go and say, hey, where's my legacy, right? We kind of have that also.
Don't expect it.
Don't expect. If it happens, fantastic. But if not, also never mind. It doesn't matter. Because you live in the moment, you're serious about your work, and you are respectful of the opportunities. But that's it. That's fantastic.
Right, so enjoy what you're doing and enjoy your work and enjoy criminal law.
Yes.
So on that positive note, thank you very much for coming to NLS and for this conversation, and hope to talk and welcome you here again.
Thank you so much.
Thank you.